Good afternoon. It's Wednesday, March 2nd. Criminal Justice Committee is called to order. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. Members, do we have any personal orders before we get started today? Okay, seeing none, I have item number 1 on the calendar, so I'm going to pass the gavel to our Vice Chairman, but I also have bills up in another committee, so our Vice Chairman is going to be the star of the show today. So, without further ado, Jerry Sexton.
It was the lousiest applause I'd ever heard. Thank you, Mr. Chairman. So our first bill is 2657 by Chairman Curcio.
Second.
We have a motion and a second.
Thank you, Mr. Chairman.
We also have an amendment. Would you like to give us the amendment code?
Yes, sir. I wish to move amendment coded 14448.
Second.
I have a motion and a second on the amendment. Would you like to explain the amendment?
Yes. This amendment would clarify pardon me. The amendment does make the bill. What we're dealing with here today is transparency in sentencing. So we talk a lot in this committee about how when a judge sentences someone and the DA is advising that victim, or even when the judge is advising or telling the offender what they can reasonably expect, they will often say, well, this comes with a sentence of 20 years or a sentence of 8 years or a sentence of 10 years. But what many victims have reported, and what we've talked about a lot in this committee, is that they don't realize that that's served at 20% or 30% or what have you. And so this bill simply seeks to clarify that a little bit, to add at least some certainty to folks who are completely unfamiliar with this system. So what it does is, it says, in order to ensure fair and consistent sentencing at a sentencing hearing, the court shall place on record, either orally or in writing, the following: what enhancing or mitigating factors were considered, if any, the reasons for the sentence, and this is the operative part, for a sentence of continuous confinement, the estimated number of years and months the defendant will serve before becoming eligible for release. The Department of Corrections shall provide the court with a form to assist in determining the estimate referenced above. So when I was working with Leader Lamberth on the original kind of truth in sentencing discussions, we were, for example, able to talk with TDOC and get some averages for certain offenses. So, okay, if someone has been convicted and sentenced to continuous confinement, what's the average amount of time that they spend incarcerated? So that's what this bill seeks to do, is to kind of draw that information out from TDOC so that the judge at the time of sentencing can say, and an average person serving a sentence of continuous confinement for this particular offense is X. Trying to give the offender some kind of true north, if you will, or at least some idea, but also give the victim an idea of what that sentence really means. So with that, I request passage.
Thank you, Chairman. Any questions on the amendment? We have one. Representative Lamar.
Thank you, Mr. Chairman. Just a quick question. So is it just to add transparency so the person who's in trouble will kind of just, and their attorney kind of have some knowledge of what they potentially be facing, right?
Chairman Curcio.
Thank you, Mr. Chairman. That's exactly right. So this is, we talk a lot about truth in sentencing this year, and I know we've had many debates in this. This is really transparency in sentencing. So even if none of the other bills that we've been debating this year were ever even entered, or if they pass or don't pass, this bill would be unaffected. So it's just a transparency in sentencing. The average person under this conviction could expect to serve X.
Representative Lamar, go ahead.
Last question. I like your bill, so I'm just asking questions, but I like it so far. My next question is, it doesn't mean that what they say the average is what you are going to be sentenced to. Am I correct?
Thank you, Mr. Chairman. That is correct. In fact, we go on to say the estimate provided is not a basis for post-conviction relief or for direct appeal for the defendant's sentence. So it will neither keep them in longer or allow them to get out sooner. So if we keep the structure we have now, where there's good time credit and there's all these other factors that are hard to predict, as I know we're going to hear about, this estimate that the judge gives would not influence anything once they get into TDOC's custody.
I'm good. Thank you.
Thank you. And I would like to say to Representative Lamar, nice hat. And we have a question from Representative Hulsey.
Thank you, Mr. Chairman. I was just going to say, to me, I like the idea. I'm 100% behind it. I think it's going to be troublesome by the time you try to factor in jail, particularly jail sentencing credits for somebody who's been sitting in jail for a year and a half before they ever go to trial, to get TDOC to come up with at that time of sentencing, have it by then. I don't know how difficult that's going to be. I'm in favor of the bill, but I don't know if it's reachable.
Chairman Curcio.
Thank you, Mr. Chairman. And I share some of those concerns, but at least instead of, we'll no longer just be saying 20 years. We'll be saying 12 years or 6 years or 4 years.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Representative Hulsey, on your questions. I would say that my experience in Henry, Benton, and Stewart counties, Carroll counties, Decatur, Hardin, is that there is a person from the local jail that sits in court during both general sessions and circuit court, and they have a printout of every person that's in custody, their name and how many jail credits they have, and those jail credits are added to the judgment that day of sentencing when the judge imposed sentencing. So I think I applaud the effort on this. It may be maybe some logistics to roll through, but I think it's important that we try to give the public transparency on what these sentences are. And my prediction is, once the public sees just how little time some people are serving on some of these serious offenses and some of these pleas that are done, that there will be quite a push for the General Assembly to take action so that the public is protected. So thank you for that. I just wanted to share my experience with you, and I think it'll work. Thank you, Chairman, for bringing this bill.
Thank you.
Representative Hulsey, your name was called. Follower? You're good. Thank you. Any other questions? Leader Lambert.
My name was called earlier, but after a couple of folks has talked, I don't know if that rule still applies or not. I will say that, if a truth in sentencing bill were to get across the finish line this year that made sentences 100%, this particular calculation becomes extraordinarily easy to do, and it takes a lot of the guesswork out of it. It's a fantastic bill. I commend both our chairman and the speaker for bringing this forward. Folks should know at least kind of a minimum standard on what they might serve. But it'd be a lot better circumstance if they knew exactly what they would serve. So I appreciate this committee's hard work throughout the year towards that goal. Thank you, Mr. Chairman, for carrying this important legislation.
Thank you, Leader.
And thank you, Mr. Chairman. And I'm glad you brought that up, because it did remind me. I was remiss in not mentioning the fact that Speaker Sexton did bring me this bill. I know he's worked very hard on it. I'm honored to get to carry it, but certainly don't deserve all the credit for the concept. So happy to do this on behalf of my speaker.
Thank you, Chairman. And I would like to say that no bill that we'll ever come up with will be perfect, but I do appreciate Leader Lambert, Speaker Sexton, Chairman Curcio, and those that are working on truth in sentencing. And I think it's a great start. We may have to make some changes along the way, but I'm grateful for it. So if there's none, we've got one more. Representative Hardaway.
Thank you, Chairman. And to the sponsor, I just want to make sure I heard everything accurately. This bill will not change any of the actual sentencing or any of the TDOC administrative roles in time being served.
Thank you, Mr. Chairman. Yes, that is correct. This does not bind TDOC in any way. It simply is meant to give the offender, also the victims, an estimate. The average person serving an average sentence for this could expect to serve X.
Representative Hardaway.
And it in no way can be used by the defendant, not the defendant, the convicted individual, one way or the other in arguing their sentence, length of sentence, or any of the other issues that may arise down the road.
Chairman Curcio.
Well, item number 3 says that it is not a basis for post-conviction relief or for a direct appeal of the defendant's sentence.
Representative Hardaway.
Thank you, Mr. Chairman, and I just wanted you to put that in layman's terms. I did read that for a sentence of continuous confinement, the estimated number of years and months the defendant will serve before becoming eligible for relief.
Chairman Curcio?
Release, not relief.
Yes, sir. That's right. The intention here is not to bind anyone, but to give transparency to the victim and to the offender.
All right, and just the last question, Mr. Chairman, and I think Leader Lambert spoke to it, but this would not affect his bill one way or the other.
Thank you, Mr. Chairman. That's correct. If we pass, however the adult sentencing code looks, once this bill passes, it's going to give the estimate. So if every sentence becomes a 100%er, then it's going to be a pretty easy job for TDOC and the judge to say, well, you're going to serve this, and it's 10 years, and 10 years means 10 years. If everything gets changed, then whatever those lengths are or estimated to be, that's what the judge will notify them of.
Representative Hardaway.
All right, thank you very much. Thank you, Chairman Sexton.
Thank you.
All right, Leader Lambert, I think your name was called twice.
Thank you.
All right. I don't think there's any other questions. We are voting on Amendment 1448. All in favor of that, say aye.
Aye.
Opposers, no. Amendment goes on to the bill. Now we're back on the bill, House Bill 2657. Chairman Curcio, do you have any more comments?
No closing comments, sir. I appreciate you and renew my motion.
Question has been called. No objections. We're voting on House Bill 2657. All in favor say aye.
Aye.
Opposers, no. Bill goes on to calendar.
Thank you, Mr. Chairman and committee.
All right. Our next bill is from Chairman Ramsey. It's House Bill 2177. I have a motion and a second. Chairman Ramsey, you are recognized.
Thank you. Thank you, Mr. Chairman, ladies and gentlemen. This is an administration bill from the Department of Mental Health and Substance Abuse Services. What it does is address the escalation of opioid abuse and fatal drug overdoses in the U.S. and consequently in Tennessee. The legislation was proposed by the Department's statewide Planning and Policy Council. Last year, we had 3,032 total fatal overdoses in Tennessee, and 66% of those were responsible for contamination with fentanyl. Fentanyl has been found in counterfeit prescriptions, illicit opioids, stimulants. It's very cheap, and it extends the effect of many of the drugs that are taken. This bill would exempt fentanyl strips from the definition of drug paraphernalia in Tennessee law. And fentanyl strips, in the Policy Council's estimation, are an inexpensive tool that brings two positive results from detecting that contamination of fentanyl. The positive results are harm reduction as well as improving overdose risk behavior. The legislation will allow Tennessee Department of Mental Health Services and other organizations to purchase and distribute these strips to people that are at risk for drug overdose with the aim of engaging individuals in recovery as a purpose and reducing the number of overdoses. And this bill has no fiscal impact. However, overdose death in the United States is staggering as far as its cost. In 2017, fatal overdoses cost us $550 billion because of health care and cost and lost productivity. The TBI, when this bill was first drafted, TBI expressed some concern about law enforcement confusion in making charges for criminal action surrounding drug paraphernalia and possession. Their concern resulted in this amendment that makes the bill. The amendment does two things. The exception to
Chairman Ramsey, are
Yes.
you on the amendment? Are you talking about the amendment now?
I will wait until we consider that, if that's your desire, sir.
Yes. Motion on the amendment. Question's been called on Amendment 13736. It's fallen from the subcommittee. So we're voting on the amendment without objection. All in favor of that, say aye. Aye. Opposers, no. The amendment goes on to the bill, and we're back on House Bill 2177. Question has been called. No objections. We can withdraw. Okay. So Representative Lamar, would you withdraw? Yes. Let's withdraw. Chairman Doggett, go ahead.
Thank you. I did have a question for the sponsor on this bill. I understand the thinking behind this, and I do have some reservations about it, but we're decriminalizing test strips. Is that correct?
Essentially, that is. However, in the amendment that was proposed by the TBI, which you just accepted, those exceptions will not apply in the presence of definition of people that are charged with the offense of manufacturing, distributing, or selling controlled substances. So those charges are still valid in possession of a drug paraphernalia in those instances. But without those instances, without those charges being made, then just the possession of the strips is taken away from criminal behavior and criminal charges. So that's the definition.
So possession of the test strips will no longer be a crime.
Without one of these other charges being in place. Now, if you have the test strips and you're charged for the offense of manufacturing, distributing, or selling controlled substances, the charge of possession of paraphernalia will still apply. But the way the amendment was written, in each incidence of possession, these three additional charges still exist.
Chairman Doggett.
Thank you. So as long as you do not possess any type of drug, then you can possess the test strips.
Yes, without those three categories.
What is the purpose of the test strip if you're not using it to test drugs?
That's a good question, fair question. The purpose of the test strips, as I said in the initial discussion, was we have an escalating situation. We have a costly and very damaging social issue. And so the test strips have been found to be a very cheap way of people avoiding the death in overdose of opioid. And several of the I guess related and issues. There's very little way, as I say, the fentanyl is a very cheap way to extend and intensify the effects of the drugs. And the fatal overdoses is something that of course, when people go out and use recreational drugs, or if they do have a habituation, they certainly don't expect to have a fatal episode. And so the issue is there's something out there that costs you $1 a strip. You can test the material, and what we're in hopes of is that these escalating deaths are going to be reduced. Number one. Also, if someone can test the material that they're about to take, they can maybe and hopefully have behavior modification that's going to either put them in rehabilitation or in some way steer them away from drugs. So that's the intent. The whole idea is to decriminalize merely the possession and drug paraphernalia. There are several different categories of it. It can be rolling papers, pipes, bill crushers, pill splitters, mortar and pestles, and things like that. And this is just one that currently holds a criminal charge. And so what we're trying to do is make this available so people will be able to, number one, reduce the mortality of drug overdoses, and maybe be placed in a position that they want to rethink their use of opioids or whichever drug that they're taking. So I hope that explains to you the purpose of it.
Chairman Doggett?
Did I answer it correctly?
I think so. The purpose of this bill is not to promote drug use.
No, it's to hopefully, under those two scenarios, reduce mortal overdoses, and you have to understand that typically there are a person in their life has 10 overdoses for each fatal overdose. So they've probably had, on average, 10 overdoses to drugs before they get the one that kills them. And so that's what this is for, is to hopefully reduce those fatal overdoses, and number two, have some behavior modification that's either going to push them toward rehabilitation or staying away from drugs. So this is not just so people can take drugs. I'm assuming that and I think the description of how these strips are used, if you're taking a drug that is rendered in a liquid form and you prepare it for injection, the proposed use of this is to use it before you do the injection. So if somebody comes up with a positive test, my guess is they're going to not do that injection. Does that answer your question?
Chairman Doggett?
It does.
But
I just find it odd, if we're not promoting drug use, but the purpose of it is for drug use. But I have one more question. I won't go down there anymore. This is traffic stops for law enforcement. You initiate a traffic stop. You're interviewing the person that you're in contact with. You see fentanyl test strips lying on the console. Are they able to ask questions to investigate further? And if so, if they find drugs in the vehicle, what kind of effect would this have on law enforcement? Positive, negative? What's the?
Okay. Not having done a lot of traffic stops recently, I'll just have to guesstimate. What this is probable cause. I mean, if you see any paraphernalia, there's probable cause for an examination of the premises, whether it's a vehicle or home or whatever. And if you determine that that there's no evidence of these three issues: manufacturing, distributing, selling controlled substances, then specifically for just the presence of the paraphernalia, this is going to take away the charges for that. But if you find a stash or or evidence that in some way they're involved in manufacturing, distributing, or selling controlled substances, and if there is a quantity of drugs there, the assumption would be these are for sale. So that would not hinder the officer in any way in examining the probable cause premises.
Chairman Doggett?
All right. Did you say that it would be probable cause to continue to search if just all you saw was the fentanyl test strips, or did I misunderstand?
There's the chairman. I'm sorry, I've been talking by you.
No, that's okay.
Yeah.
What I'd like to do is we've got the Department of Mental Health here with us today, and so I'd like to, if it's okay, we'll let them come up and speak. It may answer some of the questions. If there's no objection to that, then we will go out of session, and we'll ask Zach Blair and Kirsten Bill. Just Zach. Okay, Zach Blair. Yes, right there will be fine. State your name and who you're with for the record.
Thank you, Mr. Chairman. Zach Blair with the Department of Mental Health and Substance Abuse Services. Chairman Doggett, to hopefully help clarify, that the amendment would allow a paraphernalia charge for individuals that are also being charged with intent or knowingly distributing, selling, or manufacturing. If someone simply possessed a controlled substance illegally and they had fentanyl test strips, they would potentially still be charged for possession of controlled substances. They would just not have an additional charge of paraphernalia. This would also prevent a paraphernalia charge for someone who only has the fentanyl test strips if they do not have possession of a controlled substance. So right now, as we understand the statute and as we know the definition is written, if I was stopped and I had a container of the fentanyl test strips, which are very easy and inexpensive to get right now, I could be charged with drug paraphernalia. This would eliminate that, but if it was in concert with distribution, sale, and manufacture, there would still be a paraphernalia charge available to law enforcement.
Chairman Doggett?
Okay, so currently, right now, possession of fentanyl test strips is a crime.
Yes, sir.
Possession of fentanyl test strips with a drug is also a crime.
Yes.
What this amendment on this bill will do is remove the criminal charge for the fentanyl test strips if you're in possession of a drug at that time. Is that correct?
It would if you are not also intending or knowingly distributing, manufacturing, or selling that controlled substance that's in your possession.
Okay.
Chairman Doggett?
That answers it. Thank you.
Okay, next we have Representative Griffey.
Thank you very much, Mr. Chairman. I just wanted to get clarification from, I know we have Department of Mental Health here, maybe we got Department of Health, Department of Safety, and TBI here. Is the state of Tennessee providing any additional items that may be intended to reduce drug abuse or overdoses or something other than Noxalone? I'm just trying to get clarification.
that is-
Anything else handed out? Needles, anything like that the state of Tennessee is taxpayer money is being used for?
So we do use a decent amount of money for naloxone, absolutely. As far as the other things, I know that there are other programs throughout state government that deal with certain harm reduction methods. I don't know if that's something that we fund or contribute to. I know that a few years ago there was an exchange bill, needle exchange legislation that did pass in the state, but I believe that is under the auspices of the Department of Health when it comes to that. But the only thing that I know that we distribute widely and regularly as naloxone, or commonly referred to as Narcan.
Representative Griffey.
Could maybe Department of Health confirm if they're distributing anything else?
We don't have anyone, I don't think. No.
Oh, well, maybe we could ask TBI if anything else is,
They're not on the list, I'm sorry.
okay. That's all I got.
Any other questions? If London Lamar, I'm sorry, Representative Lamar.
Thank you. And I was going to ask to speak to him too, so you can kind of race me off the question list after this. But my question is, I understand that we have an opioid crisis and a crisis where fentanyl is getting put in drugs and people don't know it. Not sitting here saying it's okay to use drugs. I don't agree with that at all. But will this save lives if individuals who so happen to have a problem are able to know if their drugs are laced?
We truly believe this will modify behavior. This will, and the only reason we're bringing it is because we intend for it to hopefully lower overdose deaths in the state. 66% of all overdose deaths in 2020. I've told everybody that I'm scared to death to see what 2021 looks like. But they are fentanyl related, and the people that are dying are the ones that don't know that they are taking something that is not even opioid related, but fentanyl is present in there. And in order to save hopefully just one life, someone that is trying to determine whether or not they're going to take something that can kill them immediately is what we're looking to try to accomplish here.
Representative Lamar.
Last question. Thank you, Mr. Chairman, for your indulgement. My last question is, if someone, would this allow someone who feels like their drugs are being laced be able to find that out and report it by having this information?
Absolutely.
Thank you.
Any other questions? Absolutely. Then I won't. No, I'm just kidding. Chairman Doggett, go ahead.
Thank you. My colleague from Shelby County just said something that made me think. Is there, if you use the test strips, you find out that your drugs are laced, is there any immunity to that when you go to law enforcement?
Not in this bill, no.
Not
sir.
in this bill.
No, sir.
So you can test it, but you can't tell nobody, I guess, without getting in trouble.
So Chairman, I would imagine if someone took a fentanyl test strip, I'm not sure if they would have possession of the controlled substance when they identified that to someone potentially, but I would assume that would be something that they might want to know, because we continue to be overrun with this substance, and if people that can do something about it know that it's there and know where to go to get it, to hopefully eliminate it from the supply that's killing us, we hope that will lead to that. Absolutely.
Yes, go ahead.
I do recognize the issue with, I mean, it is, I've had constituents that have, in the last few months, that have passed away from, different, we all have. But just me, we've had conversation before. I have an issue with this. It feels like we are promoting or enabling in a way by doing this, and I would love to see enhancements as far as in law enforcement and prevention and detection of these drugs, because it is a major issue. We know where it's coming from. We know how it's getting here, but we don't have the numbers. Our law enforcement are running around the clock. They're short-handed, short-staffed, doing the best that they can with the funds that they have available. And I would really love to see increased funding for additional officers. I'd love to see people going into that profession. It is a calling to go in law enforcement, but I would love to see that. I think that is, if we're going to fight it, we've got to go on the offensive and not the defensive. I don't think that we should take reactionary measures. We need to be out there on the front end and going after these folks. So I understand where you're coming from. I still just have, my reservations and about the bill, but I appreciate your sincerity and your zeal, both of you, in what you're trying to do.
Thank you, Mr. Chairman.
Next, we have Representative Griffey.
Thank you, Mr. Chairman. I just want to clarify, who's providing these test strips, and are any state tax dollars used to provide these test strips?
This bill does not address any distribution, purchase, or provision of these strips. It simply takes them out of the paraphernalia definition. These are not being distributed now because they are not considered legal, and it would be inappropriate to do so.
Yes.
So if we pass this bill, whether it's a public or private entity that may be providing these test strips, it will be so that people can test their drugs to see whether they've got fentanyl in it or not. And if it's got fentanyl, I guess they wouldn't do it. Maybe they would still do it. Or, maybe the fentanyl is being used as a substitute for heroin because the price is so much cheaper, and they can get a bigger high off the fentanyl than the thing. So aren't we kind of like helping people out get a bigger high, make sure their drugs are quality, and assisting the dealers and so forth?
And Representative Griffey, that was the primary reason for the amendment, and we are glad that the TBI identified that issue because this bill as drafted now does not protect dealers because they can continue to get charged with paraphernalia as a result.
Thank you. Any other questions? If not, I have a couple of questions. In some of the cities, the major cities across the United States, we see that some of their localities have made available needles and different things for drug users. Would you classify what this bill does in the same category as that?
No, sir, I would not. And the reason why, those are specifically, and understand that there's controversy and there's value and there are downsides to providing those, but this particular item does not assist someone in consuming the product or the drug. This is simply an identification, and I think that's the big distinction between this and some of the other measures that people have talked about in the harm reduction realm.
And you said that what you're trying to do is I'm trying to remember your exact words, but you're trying to reduce drug use. Is that correct?
The primary goal for this is to reduce fatal overdoses that are resulting from fentanyl, which is the main driving force of overdoses in Tennessee right now.
Okay, do you have any data or anything that would suggest that if you're a junkie and you're about to shoot up, first of all, to use the strip, and then second of all, if you use the strip and you see that it's got some fentanyl in it, is there any way for you to know whether that amount's going to kill you or not kill you? And then you've got a choice to make as a junkie, a drug addict, and that's, I need a fix really bad. And so I'm going to take a chance. I mean, we know they use dirty needles. We know that they'll boil. I've had drug addicts in my family, and I've actually seen them boil different types of things and just shoot it up between their toes and between their fingers and anywhere that they could shoot it up. And so do you think, and I want you to look deep inside of you and say, do you think that it would make a difference to a drug addict that's needing a fix? First of all, again, I will say, would they even use the strips? And second of all, if they used the strips and they saw that it had fentanyl, would that cause them to say, sure, not going to take that?
I'm glad you asked that question, Chairman Sexton. So Brown University did a study a few years ago, took a group, and it was a small group of young people that were known drug users, gave them these fentanyl test strips. 77% of the people that were provided the test strips used them. 50% received a positive result for fentanyl when using that. And also, about 70% of people modified their behavior as a result of a positive test. So it is very encouraging that behavior has demonstrated change as a result of the results of the test. And that's the exciting thing that hopefully will lead to a reduction in fatal overdoses.
I don't want to sound critical here, so it's not meant to disrespect anything that you just said. We're not talking about a controlled environment where you take 50 or 100 drug addicts and you put them in a controlled environment to where they know that they're going to be taken care of. I guess. I don't know. Did the professors go out on the street, or did they do this in a setting inside a university? I don't know what the circumstances of the study was.
They were handed the strips to take home with them and reported back after a certain amount of time elapsed. So it was not in a controlled environment. They went to their home with the materials and then reported back to the.
And how could they confirm that what that was reported back? How do they know that that was accurate? Did they have someone there watching them all the time, or did they just take the word of the drug user?
They reported back their results. So I can't say that they supervised or if they turned anything back in, but those were the results of the study. And like you said, they wanted to do it in an environment that they naturally used the substance that they used.
That natural environment that you're talking about is wherever that they are.
Yes, sir.
But the data, I think it's suspect. And the reason I think it's suspect is because that if I'm a drug user and they're going to give me something, and then I'm going to try to give them something that's going to make the data be the way they want it to be. I'm not saying that it is. I think some of these studies are good, but I wouldn't want to base legislation off of some study that was done. I think it needs more. I too am concerned. If I had a loved one, I would certainly want them to use it. I'd take that chance. But at the same time, I think we have to be careful that we're not promoting safe drug use. And we have that all the time. And of course, we want to promote safe drug use, but not illegal. We don't want to promote illegal drug use. But I understand your intent. I appreciate it. I'm not in any way trying to say it's a bad bill. I just think it's suspect, and it could have unintended consequences.
Can I follow up with two things?
You
Jim?
sure can.
So the first part is I'm not aware of any incentive that was provided for those users to report back their results and what happened. So that's number one. The second thing is there is a 3-year sunset on the legislation, and you have my word, if this has unintended consequences, if it's not moving the needle the way it needs to, we will not ask for an extension or a removal of the sunset.
And let me clarify.
Yes, sir.
I wasn't intending that they receive something in the way of gifts or rewards.
Sure.
It was just the fentanyl strips themselves, or there may have been something there. That's probably a comment that needs cleaning up, so I apologize for that. But that is good to know. I didn't know about the sunset, so I think that makes the bill better. So if there's no other questions, do we need to vote on the amendment? Okay. We need to go back into session, so if there's no other questions, we're back into session. Back on the bill. And the amendment? Okay. The amendment's on the bill on Leader Lambert.
Thank you, Mr. Chairman. I only wanted to thank the sponsor for carrying this piece of legislation. I will say that and it's been a great discussion back and forth. The paraphernalia charge is something that you rarely see in court as a standalone. I mean, it is almost always a tack onto a different charge. I appreciate the TBI by strengthening this bill to ensure that any drug dealer or anyone else that has these strips and is using it in that way can still be charged. Now, they're going to have bigger fish to fry with the felony charges that they're facing, but at least the paraphernalia would still be there. And to the chairman's comment earlier, and I want to follow up on that, I'm glad you said this, there is absolutely no safe way to use illegal drugs. I mean, you're taking your own life in your hand if you're choosing to use illegal drugs. However, if these test strips are at least available to folks, they'll know what type of risk they're taking. I think many of them are probably going to ignore it and just go right on and use whatever drug they can get their hands on. But I think some of the folks that we've seen overdose in our community have not degraded to that point in their addiction, and they think they can still control that dangerous drug that they're ingesting. It's probably going to save a few lives. I mean, I can't tell you it's going to have a massive impact, but we've lost so many thousands of Tennesseans. To me, at least, for this particular bill, it's worth a shot to say, look, if you want to get a test strip somewhere, buy it, borrow it, get it from somebody. We're not paying for it through the state, and I hope we don't ever. But if they want to get it from somebody and test that drug, at least they can avoid fentanyl, which is killing so many people right now. Now, to me, they ought to avoid all this junk and keep this poison out of their bodies, because eventually they're going to wind up overdosing on something else and killing themselves. But that's kind of, just for what it's worth, just wanted to put a few comments out there as to why, for me anyways, it seemed like a good piece of legislation.
Thank you, Leader. Chairman Russell.
Thank you, Chairman. And I don't have a question, but I got a comment on this. I think where this is going to have an effect, the primary goal is going to be to save lives, and that's what it comes down to. And who it's going to help the most is the parents and family members of drug dealers, because you can attach fentanyl to prescription medication, drug, or candy, food, and anything else it can bond with. So, sponsor, thank you for bringing this. I'll be glad to vote for it. Thank you.
Question's been called without objection. We are voting on House Bill 2177. All in favor say aye. Aye. Opposers, no. The motion, or the bill, carries and goes on to calendar and rules.
Thank you, ladies and gentlemen.
Thank you. I thought he was back. Okay, we are on House Bill 2271 by Vice Chair Ogles. We have a motion and a second. Chairman Ogles, you are recognized.
Thank you, Chairman, members of committee. Right now in Tennessee, we have criminal asset forfeiture for trafficking, both trafficking of narcotics and sex trafficking and involuntary servitude. What this bill does is expand that 3913 to include sexual offenses that this committee last year deemed as grave. And those are rape, aggravated rape, rape of a child, aggravated rape of a child. And then I added one more, commission of terrorism as to that as well. So what this does, I mean, we've already deemed that sex trafficking is bad. We're trying to crack down on it. This just enables those offenses that are actually occur as somebody is trafficked, which is rape, rape of a child, aggravated rape. It enables law enforcement to seize those assets that are used during the commission of the crime as a result of these offenses. And with that, I will answer any questions.
Question's been called without objection. I don't see any objection. So we're voting on House Bill 2271. All in favor say aye. Aye. Opposers, no. The bill passes, goes on to finance.
Thank you, Chairman, members of the committee. Thank you.
Next on the docket is House Bill 2415 by Representative Smith. We have a motion and a second. Representative Smith, you are recognized, but however, you've got a amendment that's following this bill,
Chairman
right?
Sexton. It's drafting code 13885.
Motion on the amendment, seconds. So we're voting on the amendment, and all in favor say aye. Opposers, no. The amendment goes on to the bill. You're free to speak on the bill.
All right, thank you, Chairman. Thank you, Chairman Sexton and committee. Thank you for those who have made this bill a better bill as it's traveled through the subcommittee. And I've been working with a juvenile court judge in Hamilton County. Currently in code, harassment, stalking, and aggravated stalking is already identified. It's already stratified as, in some cases, a misdemeanor, a misdemeanor, some a Class E felony, depending on the aggravation, or if it involves a sex offender. What we have done is, because the definition of communication already in code, does include communication via social media. And what we're witnessing in our high schools, in our colleges, is the troublesome bullying and some of the stalking that goes on using the tool of social media. It's already in code, but in talking with prosecutors, because this is currently a crime of record rather than having a monetary fee, what we have done if you look at the bill or look at the amendment, it adds a minimum $1,000 fine to an adult who is convicted of a harassment, stalking, or a harassment charge. A stalking charge will have a $2,000 minimum fee that follows it, as well as a $2,500 fee with those who are convicted of aggravated stalking. But there's a new section of code that includes an adjudicated delinquent. It will serve a minimum of 12 hours of community service and a minimum of 40 hours of community service in a subsequent offense, in addition to the broad discretions of a juvenile court judge to add that to other penalties. And so with that, Mr. Chairman, I'm happy to stand for questions of the committee, but I do ask for support.
Representative Lamar.
Thank you, Mr. Chairman. Just for clarification, so this is pretty much tightening up the rules around stalking and social media, am I correct?
Yes.
Thank you, Mr. Chairman. It's not tightening the rules. It's basically equipping the prosecutors to leverage the fact that it's currently a crime of record, meaning that you're charged, but there's no penalty that other than a crime of record in the sentencing. And this allows the judge to attach to an adult a fine of $1,000 to $2,500, and then to a delinquent, there is no such reference in code to a delinquent. Where my heart is, and if the chairman would indulge me, there's a middle school student in Hamilton County that was attacked in a middle school bathroom. And she was swarmed, pictures were taken, they were put on social media, and that case is ongoing. This would not apply, but this would hopefully equip prosecutors to disincentivize bad behavior of the worst kind. But thank you, ma'am.
Representative Lamar.
Thank you. I think that I like where you're going because my generation is very, very heavy on social media. I mean, we do everything on social media. Mm-hmm. But I oftentimes have been a victim of people constantly stalking you, harassing you, sending just mean things in your DMs and things like that. But there's not a real way to hold them accountable. So I kind of really appreciate what you're trying to do here, because I do think as we're moving into the digital world and social media world, there needs to be some sort of accountability to how we even treat people in the metaverse. So thank you.
Thank you, Chairman.
Representative Smith.
Thank you, Chairman.
Any other questions? If not, we're going to be voting on House Bill 2415. All in favor, say aye. Aye. Opposers, no. Bill passes, and it moves on to calendar and rules.
Thank you, Chairman Sexton and committee.
Thank you. Okay, we're moving on to item number 5, House Bill 0457 by Representative Thomas. We have a motion and a second. Representative Thompson, you are recognized.
Thank you, Mr. Chairman and members. HB 457 is a short and simple bill. Currently, the code requires that bail be paid to the clerk of the court only in cash. This bill updates that requirement by allowing commonly used and verifiable methods of payment by adding credit cards, debit cards, and cash apps as methods of payment. Now, this bill was passed last year in subcommittee, but placed on summer study with all the other bills relating to the bail system. But I'm want to bring it here, and I am happy to take any questions.
Any questions? Yes, Representative Halsey.
I am glad you're successful at this kind of thing. I tried to get a bill that said that you can't refuse cash, and now you're going the other ways. I wish you success. I don't understand. Maybe you don't either. I don't know the the physical note on the thing says that it decreases local expenditures $1.9 million. How does that work?
To be quite honest, I am not totally sure myself.
Any other questions? Yes, Chairman Doggett.
Thank you very much, Mr. Chairman. My question is, who is taking these forms of payment? The credit cards, debit cards, money apps. Who takes those forms of payment for?
The employees in the court who normally take cash that would also be taking these forms of payment.
Representative Doggett.
Will they be assessing additional fees for? I've learned in the last several months that, which I've known for a while, but I didn't really understand the full impact of what credit cards and debit cards. There's fees that the persons who take those forms of payment incur for that. So, let's say, for instance, if they were to receive $100, they would actually only end up receiving maybe $97 because there's a card fee associated with that.
I would assume that they would be assessed those as well.
Chairman Doggett.
This is permissive. This is not, they shall take these forms. This is permissive. They may take forms.
Representative Thompson.
It is not mentioned, it is not listed as permissive. Now, I'm happy to make a change like that if it pleases the committee.
Chairman Doggett.
I would think maybe the clerk's offices or someone, if they were the ones that were taking these forms of payment, that they would probably quickly realize that they were going to be losing some of those monies that come in. And I know that there's been maybe instances where bail is returned, and if so, then would clerks end up, or it's paid out different ways? It gets applied to fees and fines, maybe, depending on the type, and then they end up losing money this way. I think, if it's mandated, if we're mandating that they do this and they take it, they're going to be losing money. If it was permissive and they decided they wanted to do that and set it up in their system to put their fees for paying with a cash or with an app or with a credit card, give them the opportunity to decide. It may not be convenient for some counties to do this. It may be very convenient in others. That's just my suggestion.
Representative Thompson.
Again, I'm sure there would be some, they would be assessed the fee that they normally are for these. I know it's a very small fee, but I understand it would be there. And if it pleases the committee, I'd be happy to tack on an amendment, whether you go out of this committee or whether you would prefer I roll it to the next week.
Representative Doggett.
Would you be opposed to rolling it a week to maybe address that, check with the clerks, and see how this would affect them? If they may come back and say it'll have no effect on us whatsoever, and there's no need for an amendment like that. But are you opposed to rolling it a week just to get that clarification? If need an amendment to do so, maybe make it permissive as well.
Sure, I can do that.
Thank you.
Before you do that, I'd like Chairman Russell to speak.
Thank you, Chairman. I noticed personal checks wasn't in the bill. Would they still be allowed to pay by personal check?
It's I had thought of that. I mean, we're trying to make this a little bit easier. We're not trying not to inconvenience the personnel at the courts, and I would think that a personal check might be a little bit more cumbersome than other means.
Chairman Russell.
Thank you. And You may just want to consider that, just because if they write a personal check, they would have written documentation when they make a payment. That's all I got.
Okay, I will. Thank you.
Thank you.
Representative Griffey.
Thank you, Mr. Chairman. I would suggest you roll this a week. I don't think I could vote for it as is, but if you'll add a provision in there that says the local clerks, anybody that accepts credit card payments, debit card payments, gets to charge a fee, an additional fee to cover that fee that the clerk or somebody uses, because Visa and all these other places, they, as part of their contract, they say the vendor, the clerk or whoever it is using the Visa machine, they have to accept those fees. They generally can't put those back on the person that's doing the transaction unless it's explicitly clear on the front end. So I would suggest maybe rolling it a week and add that. And the problem with the personal check is somebody wants to get out on bond that day. A personal check may take 3 days to clear unless it's one of the instantaneous check processing payment systems. And again, those charge an additional fee for that instant access to the money. So that would be my thoughts on it, but it's up to you what you want to do in your bill.
Representative Thompson.
Let me go back and assess all these requests, and I can come back next week with a new, with some amendments and changes to the bill.
So if it's the pleasure of the sponsor and the pleasure of this committee, then we'll roll this bill 1 week.
Okay, thank you, Chairman of the committee, and I appreciate the good questions.
Bill is rolled 1 week. Okay, we've got one other bill, and that's House Bill 1321 by Representative Hardaway. Have a motion and a second. Representative Hardaway, you also have 2 amendments. One came up from the subcommittee, and the other one is a new amendment. Do you want both of these amendments, or do you want to choose one?
Thank you, Chairman. I'd like to choose one.
Go ahead and choose.
No flip of the coin. Mr. Chairman,
yes.
We have the one that came up from the subcommittee.
Yes.
Could you call that number?
That number is 7434. And the other one is 14344.
Thank you, Mr. Chairman. The one that came up from subcommittee is going to be the same as the one 14344, except that it adds back in the concept of community terrorism, which y'all have heard me talk about for about 4 or 5 years now. And I did not intend to amend it out. And once it was brought to my attention, I requested this amendment to put it back in. That's the only difference, sir.
We have a motion and a second. And so we're voting on House Amendment 14344. Okay. Representative Doggett, you have something to say on the amendment before we vote on it?
Yes, Mr. Chairman, I do, and I appreciate my colleague and his work. He has been working on this bill for quite some time. However, this amendment is different substantially from what we passed out of the subcommittee. And so I would respectfully ask that my colleague would consider maybe moving this bill back to subcommittee if he chooses to proceed with this amendment.
Representative Hardaway.
Mr. Chairman, I would ask, I don't know, do we do it by motion, or? I would motion that we return this bill to the subcommittee.
Thank you, Representative Hardaway. I got a motion and a second to re-refer to the subcommittee. We're voting on re-referring House Bill 1321 to subcommittee. All in favor of that, say aye. Aye. Opposers, no. That motion carries. That bill is going back to subcommittee. That finishes our calendar for today, so do I hear a motion to adjourn? All in favor, go home.